Hi, Ken Lambers here, and welcome to Cltv. Today's topic is going to be another Fave 5 week. Although only four of the posts are going to be from legal criminal law blogs. One is going to be an answer to something from a netcast that's out there, Buzz Out Loud. They had a question about pagination of all things, and so let's get to it.
The number you have reached, 911, has been changed to a non-published number.
Hi, Ken here again. Pagination. Now, every one of us who's a lawyer knows exactly what that means.
You know, public domain is a great thing. Maybe Oregon could learn from it.
Maybe. Sites. This is just astonishing. A couple of sites are apparently ready to sue Oregon over the state of Oregon's claims that they cannot reproduce state law because of copyright. So they're not saying that the laws themselves are copyrighted material.
Right.
What they basically claim is copyrighted is the pagination of the laws.
The lead lines and what do they call the numbering? Basically, like what you're saying, the pagination, but there's a fancy name for it.
Yeah, the
lead
section
lines
headers.
and numbering for each section and tables and indexes. So the text of the laws themselves is public domain, but anything that organizes them, the state of Oregon claims they did the work to make them organized, and so they have a copyright on that.
Buzz Out Loud is a tech podcast /vidcast /netcast /whatevercast, and it goes over every week what's going on in the tech world. Well, Oregon had decided that tech companies who wanted to put their statutes online couldn't do so without signing some contracts and that, because not that the laws themselves were reserved, that they're free for anybody to use, but that the way they shape the laws, head notes, notations, indexes, all sorts of things like that were copyrighted, and therefore you couldn't just take them. They kept calling it pagination, which kind of brought to mind a lot of things which any of us who have gone through law school have seen. Now, I got curious about this, and specifically on this idea of pagination, and because I had a company that I used to use called Versus Law that wouldn't put pagination in their cases that they printed up. They did it by paragraphs because they were basically worried about getting sued. So I looked to see what the law is here. And as best I can tell, and this is not with like 2 weeks of research, this is more like with half an hour's worth of research, there's two cases. From 1986, there's West Publishing against Me Data Central. And we've all heard of West. How can you practice law and not know who West is? But the argument here is strict pagination. Meade says, yeah, I understand head notes and all that other stuff. That's all copyrighted, trademarked, reserved, whatever. Can't use that. But we can use page numbers because they're just page numbers. And the Court of Appeals in the Eighth Circuit says no, they're not. What you're going after is the whole body of West's works and how West puts them in its books and everything, and therefore, when you're going after the whole body of the work, that page number is just a distillation of the whole body of the work, and therefore, no deal. And so, that was the law, at least from 1986 on in the Eighth Circuit. Now, after that, we get, let's see, in 1998, in the Second Circuit, which is around New York. The Eighth Circuit is up northern Midwest. And Second Circuit is basically New York and a couple of the teeny little Yankee states tacked on. So, in this case, Matthew Bender and Company versus West Publishing. And it is about the same sort of thing. Same arguments made. It's pages, and West comes in and says, no, it's not pages, it's a distillation of all our work. And in this case, the Second Circuit says, They're page numbers, guys. Get over it. And so, the company can use pagination based on West's books in their in their online documents. And I haven't seen anything further on this. So basically what I'm saying is that when Oregon says this, that they own all this other stuff, Oregon's not in the 8th Circuit and it's not in the 2nd Circuit. It's over here in the 9th, which is just, massive circuit. And it has a good argument. It can say, this is all of our work put together, and therefore you copying it, if pagination alone is a distillation of all the work, all the indices and everything else like that, that's clearly work product that we've done out and we have rights to, and then you have to follow our rules. Now, that makes sense if you're thinking legally and you're going to go in court and argue it. In the realm of, public opinion, electoral politics, all this sort of stuff, if it catches any kind of attention, makes absolutely no sense whatsoever. But legally, it makes some sense. So I thought I'd just pass that on, and now let's move on to, what's going on in the crim law blogs. Okay, so anybody who would be under the delusion that, we're high class here is gone now, so we can go back to being, who we usually are, which in my case is, let me see, how Wendy Pundit put it, the big hat-wearing doofus who likes his dogs but collects warhammers. Okay, so we've got 4 more to cover. First is from Objection, and in Objection, the author is talking about how, the things he's only been practicing for a little bit less than a year as a prosecutor, and the thing that absolutely drives him nuts is assault and batteries. Now he, and maybe his state has somewhat different laws in mind, he seems to mix up assaults and batteries, or call them all assaults. In Virginia, assault is the threat, batteries the unwanted touching with intent to commit harm. Basically pain. But he goes on, and the classic thing that all of us face, prosecutors, defense attorneys, everybody faces. On the one hand, you got the charge that was taken out, but it's 3 weeks, a month later, and girlfriend, wife, baby mama, whomever, just does not want to press these charges anymore. He's not really that bad a guy. He's never done this before. He'll never do it again. He's only done this when he's drinking. He stopped drinking, etc., etc. We've all been in those cases, and the lady comes in and wants to drop the charges. Man, it happens with guys too. A couple guys who were drunk and at the time really pissed at each other, and now guy one just wants to let it go. And then there's the other hand where you got the person who wants the death penalty for the fact that somebody said, I'm going to spit on you if you don't stop. Technically an assault, technically convictable. But you go in front of the judge with that and put that trial on, and he's pretty much going to think you're insane and not be very happy with you. So you get those two extremes, and there aren't too many in the middle. Well, there are some, but not as many as you'd think. So he's a little bit upset with that, and go check it out. Then we get to Norm Pattis, who's talking about Eve Drain, and he's talking about how the bar, ABA, and I guess probably because of it, the local bars and everything, are all upset because, women are leaving the bar. And, they're leaving at a higher rate than guys do, and they're leaving it earlier, leaving after a few years of practice, and, oh my goodness, we've got to solve this. And Norm looks around and goes, there might be some reasons for this. And he doesn't go the typical path we all usually kind of think of as, she marries a guy and gets pregnant. That's not really compatible with a job where you're working 90 or 100 hours a week and have to bill 3,000 hours a year. It's not compatible with that, so you have to drop out. He points out, well, a lot of what we're seeing here is women feel like they have more choices. They don't feel like they're obligated to stay. They don't feel like they've got to be the one out there, earning the bread money and all that good stuff. And well, obviously there are things like, possibility of childbearing. He doesn't say that, interfering, and and he talks about how we've all seen them, and we all have. If you've been in a trial court any time in the recent period of time, we've all seen women who are practicing law and practicing law well. They're not in the numbers that guys are, but they're out there practicing. And, if they choose to make that, if they feel they have that choice to make, I'm not sure that all these proactive measures which they're talking about are going to make much difference. Okay, then we get, let me see if I can pull up the next one. Bad Court Thingy. Bad Court Thingy, who's talking about, we all know those phone lines. Bigger cities have these. We don't really have them where I'm at right now. But bigger cities have these phone lines where you can call in and snitch for money. Or whatever you want to call it, inform for money. And, they're useful. You find out that this house down the road is selling heroin, or that place up there, or there's somebody who's fencing goods at the pawn shop, or, all sorts of stuff that can be useful. Or you find out where somebody's hiding who, is wanted for manslaughter or murder or something like that. But Bad Court Thing, he's talking about how, well, apparently, at least around where it's at, there are people that are doing this in a serial manner. They're calling in, and getting money for each time they inform. I'm not sure how it works in most places. In Richmond, it seemed you got a number and you would call in, you'd give them information, and there somehow you were supposed to be able to get the number without identifying, or get the money without identifying yourself. And if you're somebody living in a neighborhood which is pretty pretty full of crime, you could probably make a good bit of money out of this. 2 or 3 snitches a week and $7.50, and a little bit of justice gets done, and it's not necessarily a bad thing. It's kind of a weird way to make a living, though. Gotta say that. And finally, we come to Missouri criminal defense lawyer, and it's not really one post; it's actually 3 posts that Missouri criminal defense lawyer did over the last week or so, about juries not following the law and jury nullification and all that. And I've gone over jury nullification in depth previously. Missouri criminal defense lawyer throws up the straw man of, well, then if they can disobey the law, then they can convict in without the law being with them. And he says, no, we can do it so that only defense attorneys get to give the instruction that, if you don't believe the law is fair or fairly applied in this situation, you can't ignore it. And there I go back, if I'm not going to rehash the whole argument, I go back to the same thing we had before. Yeah, and you can stand there in front of the jury and go, and my client is from Serbia, and the victim was from Armenia, and we know what those Armenians are like, and Serbians are people who should not go to jail for shooting Armenians. And if you don't think those type of arguments have been made, you really need to look to the history of the South. Okay, now we've gotten ourselves on kind of a down point, but I'm going to close up today. I'm going to close up on a Memorial Day theme, and I want everyone out there, find your nearest person who served and go say hi to him and thank him for what he did. And you might lift a glass or a cup or a bottle for those who didn't make it back. I'll see y'all next week.